in 2019. So are you fit for what's happening in industrial relations in 2019? So what we want to do is give you a bit more knowledge and understanding, and looking at the session overview and what we're going to be discussing, we're going to have a little brief overview of your long service obligations under the Long Service Leave Act 1955. Then we're going to have a look at some changes to our website online, and within that we've also got some updates and in our long service leave calculator, so we'll have a look at that as well. What's new for 2019? And looking at some common issues from the award review process through the Fair Work Commission, we've got some new provisions that you may or may not be aware of, but it's an opportunity to sort of go back and just have a check and just see where you're at leading into 2019 and your obligations. So we've got this casual employment scenario, and that's looking at your obligations in regards to having a regular and systematic casual employee, and having done that over a period of 12 months, having the opportunity to look at seeking to convert. So we're going to have a little brief overview of what the major issues are and requirements within your modern award in regards to that. The family and domestic violence leave and the new provisions there, again, modern awards have now got these model clauses within the modern award system that deals with these issues. So family and domestic violence leave, we'll have a look at that as well. Also family-friendly work arrangements, and looking at that being part of an award provision, but it is underpinned by the Section 65, the right to request flexible work arrangements under the National Employment Standards. They've tightened up and looked at the issue around payment on termination of employment. So the old issue around, well, how long do we actually have to wait until we get our wages if we're either being terminated or resigning or leaving employment for whatever reason? I've always been asked over the years, well, how long do I have to wait before I'll be paid all my money's owing to me? So we're going to have a look at that now, because that's something that's actually come from that 4-year review of modern awards through the Fair Work Commission as well. Public holidays. We're going to have a look at the Public Holidays Act 2010, New South Wales, and we're looking at how that interacts. And we've got Easter coming up, so we're looking at Easter and Anzac Day. So we're looking at 5 public holidays coming up in the end of April, and you know, there's 5 days there that employee may be entitled to. Also, looking at wages, records and pay slips. So what are your obligations there? So there really is just a session today just to get you in the mindset, thinking and looking forward and moving into 2019. And do you have these things in place? What are you thinking about as far as your industrial relations obligations? So it's just an opportunity just to give you some food for thought, and just thinking about doing some review and evaluations of where you're at and what are your obligations there as well. So, and having said that, and just looking at long service leave, the question that I'm asking is, well, do you have any employees entitled to long service leave? Do you know where your employees are at as far as your long service leave obligations are concerned here in New South Wales? When we look at the long service leave provisions, and just to reinforce around the long service leave obligations and where do you go to get that information, well, if you're in the private sector in New South Wales, then you are national system employers and employees. So then we go to the National Employment Standards, and long service leave is one of those provisions, but it's a transitional entitlement derived from a pre-modern award. So more than likely, the majority of the employers and employees in New South Wales would be covered by the Long Service Leave Act 1955. And it applies to most employees in New South Wales. So there are those that actually are not covered by the Long Service Leave Act 1955. Look, if you want to go and get a lot more detail, we do have our face-to-face long service leave workshops where we'll spend a bit more time and effort in explaining all the responsibilities under the long service leave. So we could be coming to an area near you in regards to delivering that information. For example, I was in Coffs Harbour last week, and we had a very, very good response to people turning up to get some better understanding of the Long Service Leave Act. I'm in Hornsby next week as well. Then my colleague Deb, she's heading down to Griffiths, so she's actually running her face-to-face long service leave workshop there as well. So I'm just going to give you a quick overview here in regards to just making you think about your long service leave and just getting this idea of being fit for industrial relations in 2019. Because long service leave is one of those things. It's not always coming across your desk every day like personal leave or annual leave or ewing wages. Then all of a sudden you'll get 1 or 2 or 3 employees all hitting that event, and the event is at 10 years. So the entitlement at 10 years of continuous service, you're entitled to 2 months or 8 weeks of long service leave. Now there is a further entitlement of 1 month, and a month being 4.33 weeks, for each completed 5 years thereafter. So once you reach 10 years, there is another month available to you then at 15, then at 20 years. But of course, when we're looking at up until 15 years, it is going and incrementing for each completed year, month, week and day until 15 years. Then from 15 years onward, it is only completed years that count to the next increment. But if I had been there for 12 years, 6 months, 3 weeks and 2 days, then my ability, and I'm staying in employment and I want to sort of take some of that leave, I'm only able to take the 10 years entitlement. So I'm only able to access the 8 weeks. The other months available to me then at 15 years. But if I left employment and I was leaving employment at, for example, 12 years, 6 months, 3 weeks and 2 days, then I'd be entitled to all my long service leave. So, because once I get to 10 years, then I can either take the leave or I am paid on termination. There's no cashing in of long service leave. So once the event occurs, so once I get 10 years of continual service, and it's regardless whether I'm employed as full-time, part-time or casual, and casual employees have been entitled to the long service leave enforced under the Act since the 9th of May 1985. So any casual service from that time and that date will count as service work towards their calculating the period of long service leave. So, and when we look at that, so once you reach 10 years, and the Act is, the intention of the Act, and when we look at the spirit of the legislation, it says, well, once you reach 10 years, you've got 8 weeks there, whether you're full-time, part-time or casual, should be taken as soon as practical once it becomes available to you. So it becomes available to you at 10 years, but subject to the needs of the business, or maybe postponed to another mutually convenient date. So you've had a look at it and there's been a discussion and been a decision, well, no, you really don't need or want to take it at this point in time. It can be then postponed to another mutually convenient date. But if you are going to take the 8 weeks, for example, because you've been there for 10 years, it is to be taken in one continuous period. So the Act is saying, well, it should be taken as soon as practical once it falls due. So it falls due at 10 years, then at 15, then at 20, in one continuous period, or if agreed, it then can be taken where the leave owing to you is 8 weeks or less. It can be in 2 separate periods. Where the leave owing is greater than the 8 weeks, it can be broken into 3, or if it's greater than 19 weeks, the leave owing, then you can go then into 4 separate periods. So it is depending upon the amount of leave that is available. So it is to be taken as leave, or it is paid on termination of employment. We do have a pro rata payment for long service leave, and when we look at this next slide there, it just gives you a bit of an indication there. So from 0 to 5 years of employment, so day 1, day 0, that's important because that's your start date, and that's a very important date to keep records of. But when did the employee actually start? So that start date is very important. But from 0 to 5 years, the Act is not providing any entitlement. When we reach 15 years, then we're looking at a potential pro rata payment. So it's a payment of long service leave. It's not taking the time and the money. It's actually just a payment. But there are conditions applying to that. So if you've got more than 5 years but less than 10 years service, then the conditions that are attached to that payment for pro rata, we do get a lot of inquiries and discussion around these issues, and that is the employee's got to show cause they are resigning as a result of illness, incapacity, domestic or other pressing necessity, will be terminated by the employer for any cause other than serious or willful misconduct or the death of the worker. So it just sort of gives you the indication there that it's got to fit into one of those circumstances around the pro rata long service leave payment. If someone just resigns on their own free will, on their own accord, to go to another job, well, then there is no obligation under the Long Service Leave Act unless the employee can show cause that they actually did resign as a result of illness, incapacity, domestic or other pressing necessity. And then you see here now, once you reach 10 years, well, that's not taken into consideration, because once you reach 10 years, the event occurs, and that's when you become entitled to your long service leave. So at 10 years, it is 8.67 weeks. There's an additional month available to you then at 15 years. So at 15 years, you're looking at 13 weeks of long service leave. Our website, and a lot of good stuff there. You can actually give us a call. We've got our phone service, so we've got our operators Monday to Friday, 8:30 to 5. There's always someone ready and available and willing to assist in any of your inquiries in regards to your long service leave issues. You can give us a call on 13 16 28. We've got a lot of frequently asked questions that will assist with your to give you provide some advice and assistance in regards to long service leave as well. There is now an easy way to lodge a complaint by using the online application form, but there's a process. So if you've got some issues around a dispute involving a long service leave, well, then give us a call. We'll have a look at the process on our website as well. We do have the calculator. So our new look calculator now allows you to put breaks in service, which is very important, because when we're looking at our 10 years of continuous service, so we're looking at this definition around, well, what is continuous service? So continuous service to the same employer. So, and there are issues there within that whole circumstances around being continuous. What does that really mean? So what counts as service and what doesn't break? What doesn't break your service, but what doesn't count in an absence. So if you've got parental leave, for example, is one of the most common situations where an employee may have some break in their employment because going off and having that unpaid parental leave. Well, that's not going to break this service. So any service they had prior to going on their parental leave period will still count. Will still be there, but that break period will not count as service worked. So, but we're looking at that unpaid stuff. So it's very important. One is you keep day zero, what's the date they started, but then looking at any of those unpaid breaks. So parental leave is the best example there. The unpaid break, you need the start and the finish date of that break, but there is an ability now. One is to put breaks in service in the calculator and the calculation, but also then add additional breaks, because there could be a circumstance where an employee may have more than 1 or 2 or 3 separate periods of parental leave as well. So that's important to keep good and accurate records, and particularly your breaks and your starting and your ceasing dates as well. So your dates are very important for your record keeping purposes, particularly in regards to calculating your long service leave. So that's our calculator. So just thinking about what's your plan. So have you done a survey? Have you thought about, do you know where your employees in your organisation, do you have anyone that's either reached that 10 years of employment or looking at getting there, and then all of a sudden you might have a few staff hitting that event stage, or that benchmark of 10 years. And so actually, have you looked at the Long Service Leave Act, and all of a sudden you go, okay, I've got some employees, and that's my common situation is when people are asking us for advice and assistance. So you're going, well, I wasn't aware of it, but now I've got some employees that getting that entitlement, they've had it there, or I don't really know how it works or how it operates. So get organised, and that is by understanding your employee entitlements in general. But if we're just looking at long service leave, what's your plan? How are you going to work that out? Ensure accurate and detailed and up-to-date records are kept, and that is particularly around the starting and the ceasing dates, any breaks within that time as well. Very important. Are you training your management team on how to process approval of applications? Because it says that it should be taken as soon as practical, but in my experience, most employers and employees are not really thinking about long service leave. So they're not sort of having that date on the board saying, all right, here's my 10 years, I'm really going to be taking it then. A lot of the times is that that's not really having that awareness in the workplace around the entitlement to long service leave. And even then thinking about, well, can you allow them all those 3 employees, for example, hit that time frame and they all want to take the same time all at once? Can that happen? It's depending on the needs of the business. So is it practical to allow everyone to go at the same time? So what do you have a process in place in your workplace around applications for the leave and how entitlements can be taken. What are your staff intentions about, and that will help you around the issues around future workforce planning. And are you implementing a process or procedure for the applying for the leave? So you can have a policy around your leave, and say your personal leave, your annual leave, and all that stuff. But in particular, long service leave, your policies around that. But also, then, what is the procedure within the policy? What do they need to do? What are the steps? Who gives the approval? Who's authorised to give the approval in regards to someone accessing that leave? Does the payroll person in the organisation, are they aware that someone's accessing long service leave? Are you paying it correctly? Because we established the entitlement, but then how do you pay it? And that's the important element. The entitlement comes first, then we look at, well, then how do you pay it? Take some time, check out our website, get some more information, get some advice and assistance. Have a look at the Long Service Leave Act. We are providing those face-to-face long service leave workshops, and the next month's topic for our webinar, our online live webinar in the last week of March, is going to be long service leave. So we're going to actually giving you that opportunity again, not only face-to-face in different locations where we're coming to you, but we're also going to be just revamping and have another look at our long service leave Act and how to give you some more advice and assistance there. So if you don't know, jump onto our website, industrialrelations.newsouthwales.gov.au. Get fit in 2019. What's your plan in relation to long service leave? So there's some brief information there for you, but there's more information for you available on our website, or have a look at coming up and turning up to one of our workshops face to face. All right, what's updated? What's changed? What do you need to know briefly in regards to your modern award? Well, modern awards have been reviewed every 4 years. The Fair Work Commission have got to go through the modern review process. They're looking at common issues within the modern award system. Your individual modern award itself may have been going through some updates, changes, and had some new things put into it. There's some common issues there that we can actually let you know now that you may be aware of, and you may have heard some talk around this issue around casual employment. Now, these are model clauses that most modern awards actually now have built into them as a clause within itself within your modern award. There could be the exception to the rule. There's going to be some modern awards that may or may not have these things, but it is a matter and a situation where you need to go back and double check your modern award. Always go there, go to the Fair Work Commission website, look at your modern award and just see, okay, what's changed? Is it the same, or has it got something new in there for you? So because we're looking at casual employment, awards now provide, and most modern awards provide, a casual conversion provision that if in the preceding 12 months that casual has been working regular and systematic, and they've been working a similar pattern to a part-time or a full-time employee, then after 12 months, that casual employee now has this situation where they actually can request to that employer to convert, therefore, to full-time or part-time. Now, what the obligations within those clauses, and when you want to, where do you find that information? Go and have a look at your types of employment clause within your modern award. Look at, because your types of employment clause lets you know as an employer how you can engage someone under that modern award if they're covered by it. Now, when you go into the detail and you go into the casual clause, it'll start with, well, a casual is just one engaged and paid as such, minimum engagement, maybe 2, 3 or 4 hours, paid per hour, entitled to loadings and penalties, etc., etc. But further down within that clause itself, if it's got the conversion provision, that's where you're going to find it. And it'll say there, casual conversion to full-time or part-time. Now, what the obligations are there, and the first thing I'm going to suggest, and the best advice I can give you, is actually read the clause. Have a good detailed reading and getting a better understanding of what does it really mean about converting someone. Do I have to do it? Do I have to go around and ask everyone? Or is it more that this is putting the employee, that they've got the opportunity to ask to convert and opting in to wanting to then convert their status of employment from being casual to part-time, because that previous 12 months has dictated that it's a similar pattern to being a part-time or full-time employee. But how do they know that? Well, do you have to tell them? Well, yeah, there's always that situation where an employer should be letting employees know about all the employer obligations and their entitlements, but they've gone under the model clause. They said, well, to ensure that employees know that they've got that opportunity to ask to convert, then a copy of the provisions must be supplied to a casual employee within 12 months of engagement. And that doesn't matter whether they're going to be that regular and systematic, or they're that casual that is irregular, unsystematic, unpredictable. So that's a true casual as opposed to someone who's a regular and systematic casual. Now, if you've got a casual employee, because this provision came into 86 modern awards as of 1 October 2018, and what they said within that model clause, if you've had existing casuals as of that date, then they've got to have been given a copy of that model clause, that casual conversion provision, by 1 January 2019. Well, you know, we're up to the to nearly the end of February here, so if you haven't done it, then you need to look at, if you've got casual employees that have been employed as of 1 October or before that, then they should have already been given a copy of the conversion clause. Now, there is no one set form. So I was asked the other day, is there a form I can provide? Is there somewhere I can go to get a form? Well, the detail of the conversion clause is in the modern award. So it's a matter of going to your modern award, copy and pasting it, putting it into your own document with the employee's details, and when you issue it, proof and evidence and documentation is very important. Asking them just sign and date the fact that they've received a copy of the conversion clause, so they've now got that. It's like that Fair Work information statement. Documentation and evidence are very important, and even there we suggest the best practice would be get them to even sign and date that, so you've got proof and evidence to say you've issued it. So because this is a modern award provision, so a breach of the award can attract some penalties. If you don't do it, then there are penalties attached to not following through with the provisions of the award itself. So so at some point during that first 12 months of engagement, you've got to give someone who is a casual employee, whether they're systematic or they're unpredictable, a copy of the casual conversion, because they could turn into that regular and systematic casual as well. So, but if you've got existing casuals, well, then they should have been given a copy of that casual conversion clause already by 1 January 2019. So, never too late to jump back on there and catch up where you should have been in regards to your obligations under your modern award. Family-friendly work arrangements. Now, the National Employment Standards, and part of the 10 National Employment Standards is the right for a full-time, part-time or casual employee with at least 12 months service have the right to request flexible work arrangements. Now, there's a whole set of circumstances where they fit into that right to request flexible work arrangements. For example, if the employee's got a disability, if they've got a formal caring arrangement, if they're an employee or a parent with the responsibility for care of a child who is of school age or younger, then they've got a right to request flexible work arrangements as well. Now they're saying is, well, we've got this provision within modern awards. We've got this clause there that if someone's made a request under Section 65 of the National Employment Standards, then the modern award will also support that as well. So under a modern award, an employee may request a change in working arrangements if they've made a request under Section 65 of the National Employment Standards of the Fair Work Act. Any request but should be put in writing, and any response is to be determined in writing as well. Now, the request should be outlining the circumstances of what they're asking for, and you've got 21 days from the request to respond to that request, and it's got to be in writing and a detailed explanation around either you are granting the request or no, you're not. And if you're going to say no, you need a really good and clear business case as to the reasons why you're not granting their request. Or you may not be able to meet all their requirements of the request, but you seem to be moving towards, and you negotiate around that as well. So, and now we've got this family-friendly work arrangements provision, but underpinned by Sections 55 of the National Employment Standards. Now, well, not a common thing, but an issue that's been sort of coming around, and it's a contemporary issue, leave to do with family domestic violence. Now, a lot of organisations are out there and looking at providing paid leave through enterprise agreements or other organisations and providing that. We've now got a situation where modern awards now have got this model clause around leave to do with family and domestic violence. Effective in your modern award as of 1 December 2018, there is an entitlement there to 5 days unpaid leave. Now that 5 days unpaid leave is available in full at the start of each 12-month period of the employer's employment. So every anniversary date, there's a rolling 5 days leave available. You don't accrue it, so if you're not using it, you're not losing anything. It's just 5 days there, but from day one of the anniversary date, available in full to full-time, part-time, and casual. So it doesn't accumulate. So if you're not using it, then you're not losing anything. It's there to be available if it is something that you want to, an employee wants to access to help them support to deal with those issues around that and support them with that family and domestic violence leave. So, but the employer and the employee may agree that the employee may take more than 5 days unpaid leave. So it's a minimum of 5 days, but there can be an agreement that you want to provide them a bit more support with that unpaid leave. The clause goes on to say that it doesn't count as service, but doesn't break the employee's continuation of employment. So very importantly, with that, it is subject to confidentiality in handling the information relating to the leave. So you want to be very mindful around the obligations around the confidentiality provisions of someone accessing family and domestic violence leave. So really it only needs to be those people involved, those who need to know in regards to that. So it is subject to confidentiality. Defines the coverage to family members, also including persons related to the employee according to Aboriginal or Torres Strait Islander kinship rules. Now, if you, just as a bit of a helpful suggestion here, that if you want to know a little bit more around that side of things, then New South Wales Industrial Relations, we've got a great unit, Aboriginal Community Engagement Unit. They do a lot of great work. They help Indigenous communities with information for their workplace. So they've got a newsletter, the Two Rivers, so there's always some stuff. You can subscribe to that as well. You can book an appointment and you can call them on 1300 361 968 or 02 9228 5985 if you want to get a bit more detail around, well, what are the kinship rules for Indigenous or Aboriginal Torres Strait Islander? What does that really mean? So, or you can book an appointment with them, or you can actually email them as well. So you can contact our ACE unit, Aboriginal Community Engagement Unit, so at aceu@industrialrelations.newsouthwales.gov.au. All right, we've got this issue around the update to awards on payment of termination. As I mentioned, we've always been asked over the years, well, I'm leaving employment for whatever reason, but how long does my employer have before they've got to pay me? Now, I've left and I'm paid fortnightly, but I only got paid yesterday. Do I have to wait another 2 weeks, or paid monthly? Do I have to wait for the next payroll run? Well, that's been an issue. It's a common issue that the Fair Work Commissions has looked at, and they've gone now, well, we need a model clause. We need to tighten up this payment of wages on termination. So effective as of 1 November 2018, the employer must pay an employee no later than 7 days after the day on which the employee's employment terminates any wages under the award for any complete or incomplete pay period up to the end of the day of termination, and all other amounts that are due. So you now only have 7 days. So if you're in that situation where you're paid fortnightly, you're just being paid, and you're terminating the next day, then you've only got 7 days from that. The employer can't make you wait till the next payroll run, because the rules are now that if they don't, then there is a breach of the award. There is a big difference, but with long service leave laws and entitlements. So when you're looking at long service leave, and particularly in the New South Wales Long Service Leave Act 1955, that Act says we either take the leave as paid leave or you're paid on termination of employment. So there is no leeway giving you 7 days. The Act says is you are paid on termination of employment any long service leave entitlements that you are entitled to, whether that's a pro rata payment or whether or not it's leave that you become entitled to you haven't taken. So that sort of a bit of a difference there in regards to this 7-day rule now. So check it out. Have a look at your payment of wages clause under your modern award, because that's where you're going to find this detail as well. So it's always good. Just go back and just check your modern award and just find out, well, what's going on here And what's happening with my modern award, if you haven't looked for a while, you may be surprised that there's a few different changes and variations and updates and variations to your award itself. So get access to a copy of your award. What's your plan? Go and have a read. That's your starting point. Ensure all staff are aware of new and existing entitlements. Have a look at any documentation that's required to be given. For example, have they got a copy of the model clause? How are you doing that? If you're asked, did you issue it? Do you have proof and evidence? Is there a document that you can have there? Did the employee sign and date it? And there's nothing sinister about you asking them to sign it. It's just common sense to say, yes, they're acknowledging that they've actually got the document, and that's a great thing to have. Any documentation required is given to them. Train your management team to be aware of any changes. Review how the business is going to implement any obligations. What are the IR implications of any unreasonable refusal to access entitlements? And that is, have they asked for a request for flexible work arrangements? Have you responded back to them within 21 days? Have you really outlined, if you're going to say no, you haven't just said no, have you explained to them in further detail to the reasons why you can't support their request? Implementing a standard practice that remind employees of business expectations around submitting applications for flexible work applications, including accessing and taking of leave. If you've got someone going that was full-time, go off on parental leave, they can't just be expected that they're going to come back and think that they're going to get their request for flexible work arrangements. You need to let them know. You need to communicate. You need to actually making sure that people are aware, and so talking to them leading up to, during and after, and managing their expectations in the workplace as well. Take time to understand any additional support to staff that may be required. If someone is accessing family domestic violence leave, how are you supporting with them as well? So how are you doing that? Do they know that they can do that as well? So making sure employees know that, you know, they've got these new entitlements there, and that there is an opportunity, if they need to be supported, that there may be something there that you can do as an employer as well. So what's your plan? Are you getting fit for all these new changes to your modern awards as well? All right, let's move on and have a look at public holidays and being fit for public holidays in 2019. We've got through that Christmas, New Year, Australia Day. Now we're heading up to Easter and Anzac Day as well. Now, when we're looking at public holidays, you can go, well, my modern award has a clause that talks about public holidays. Now, you'll find that under your modern awards, it's not going to tell you what a public holiday is. So you started at the modern award. Your modern award will tell you what you get for work performed on a public holiday. Is there any penalties or loadings that are applicable, and what they are? Check your modern award out. But to understand under the national system and looking at the NES, it actually does talk about public holidays. It actually outlines and determines names eight public holidays, but it does go on to say, and any other day gazetted as a state or regional public holiday. Okay, well, we're here in New South Wales. We have the Public Holidays Act 2010. So the New South Wales government is gazetting statewide and regional public holidays. Now, within the regional banner, we do have a situation where we have local public holidays. We also have this concept around an event day. And what does an event day really mean? Is that a public holiday for industrial relations? Well, briefly, no, it's not, but I'll explain to you why. Back to the NES, and the NES actually does say, if that's a day the employee would normally work, then that employee actually has the right to be absent from work on a day or part day that is a public holiday. So we've got to determine what is a public holiday. Well, we gazette the public holidays statewide and regional, local public holidays as well. If you're an organisation that does operate all over public holidays as well, so you do want to work on public holidays and there's an expectation to work, then there can be a reasonable request by the employer to the employee that you do require them to work on that public holiday. Now, that's fine. The employee then can reasonably refuse the reasonable request. I do suggest you go and have a look at the National Employment Standards and look at the public holiday clause there around this right to be absent and the right to request, and what's a reasonable request and what's a reasonable refusal. But we're just getting, when we look back now at the Public Holidays Act here in 2010 here in New South Wales, and what is a public holiday? Well, we've got some rules around when certain days fall on weekends, when a public holiday falls on a Saturday or a Sunday. Now, in particular, where we've got Australia Day, January the 26th falls on a Saturday or a Sunday. Now that's happened here in 2019. It was Saturday the 26th of January was Australia Day and observed as such, but the Public Holidays Act itself said, well, there's no public holiday on that day, as the following Monday will be declared the public holiday. So yes, we observed Saturday the 26th, but the public holiday for Australia Day was actually Monday the 28th of January. Where we have New Year's Day, Christmas Day or Boxing Day falling on a weekend or a Saturday or Sunday, that day will be, so that's the opposite to Australia Day, Boxing Day, Christmas Day or New Year's Day. If that's on a Saturday, Sunday, that will be the public holiday on that Saturday or the Sunday, and another day will be gazetted. So there is their potential there. If Christmas Day, Saturday, Boxing Day, Sunday, you're going to have Monday and Tuesday as additional public holidays. So for 2 days, you'll actually have 4 public holidays. What happens if someone is entitled to, and they're a 7-day shift worker? So is there something there? So what does your modern award then say in regards to that public holiday itself? So just looking at the table there of the public holidays, and these are statewide public holidays, barring bank holiday. Bank holiday itself is not a statewide public holiday. So there are only certain banks and organisations here in New South Wales that either would observe that as an additional day or a substitute day, or as a public holiday themselves, but it's not a statewide public holiday. We've got New Year's Day, Australia Day, but looking now at Easter coming up here in April. Friday, Good Friday the 19th. We've got Easter Saturday. Now, it's always been the misconception out there, I've heard over the years, Saturday's never been a public holiday. Well, it has. So we've got Easter Saturday. Easter Sunday now, because the Public Holidays Act 2010, you now can have a public holiday gazetted on a Sunday. So we've got Friday, Saturday, Sunday, Easter Monday, and we have Anzac Day coming up on Thursday the 25th. So there are actually 5 public holidays coming up towards us in April. So here's a time and an opportunity now to think about and look forward and go, okay, well, what are we doing as an organisation? Do we want to operate? Do we have employees that work that day? Are we going to need them to work, or we're not worried about it because we're closing anyway? Are they entitled to the whole 5 days or just the 3 days because they only work Monday to Friday? So you need to look at your industrial obligations there and just have a look forward and just have a look at that. You'll see there in next year in 2020, we've gazetted. So this information's on our website, industrialrelations.newsouthwales.gov.au. You'll see there, Day 2020, and I know we're getting ahead of ourselves here a little bit. 2019 hasn't passed, but I tell you what, it's going quick, isn't it? We're going up to the 1st of March tomorrow, so this year's going quite quick. Saturday the 26th of December, you'll notice there, that's an example where Christmas Day, Boxing Day, and New Year's Day falling on a Saturday or Sunday, that day is the gazetted public holiday plus an additional day gazetted. So the additional day is gazetted because Boxing Day falling on a Saturday as well. So what's your plan in regards to, are you aware about these days? Do you have employees that are actually working there as well? Now, I did mention statewide, and I did mention local public holidays, and local public holidays are deemed to be regional public holidays under the Fair Work Act and the National Employment Standards. Now, a local public holiday declared after the 31st of December 2011 are now made under the Public Holidays Act by ministerial order and published on the New South Wales Industrial Relations website. But what it is, your local council in that area, they'll decide, they'll make an application to the minister through our department to get that day recognised as a local public holiday. Now, that could be a whole day, a half day, or a part day. The application's made and is granted and is actually published on our website, and that'll tell you what the day is named as, the area in which it applies to, and the time frame that it applies. Is it a full day, half day, or now they're talking about part day public holidays as well? So some examples here that you've got that we do get applications. Muswellbrook Cup, we've got Scone Cup, we've got the Ningen Show, we've got Peak Hill, we've got Lismore Cup Day, we've got Jacaranda Festival up in Grafton. They're all days that we've had in previous years that have been applications made, just as examples, because we don't know until the application is made to the minister through our department to get the day recognised and gazetted onto our website, and that's where you find that information as a local public holiday. The opposite to that is there could be a request of the council or a local government area to the minister to declare a specified day or part day to be a local event in the local government area or in a specified part of the local government area. Newcastle Show is on this weekend up in Newcastle. The application could be by Newcastle City or Lake Macquarie City Council. They could have applied to get that day gazetted as a local public holiday, but the decision for the application for this year by those two councils around Newcastle Show was a local event. And you've got to say, well, and question, well, why are they even bothering even doing that? Well, they're just acknowledging and the significance and the history of that day, because Newcastle Show has been going around for a long time, and so they're just doing and just recognising the significance and the history of that day itself. So it is important, but if you're in an area that you know that there is a public holiday in that area that you know of, well, the question you need to ask is, well, how is it being gazetted? Is it a local public holiday or is it a local event day? Now, if it's a local public holiday, then it is. A local public holiday is deemed the original public holiday, so therefore it is recognised under the National Employment Standards. But a local event day doesn't make it a public holiday for work purposes. So, if we're just looking at that issue, just to clarify it a little bit further, if we take Newcastle Show, for example, yes, it's on. Yes, it's been gazetted as a local event day. But if someone's working in that local city council area in Newcastle, working on the day, then it's not a public holiday. There's no penalty payments for that employee if they are working. If that employee would like to go to Newcastle Show and have the day off, well, they actually apply for leave without pay, a roster day, or take an annual leave day to attend Newcastle Show. So, but if it was gazetted as a local public holiday, then that would be different. And that employee would be entitled to that public holiday where the employee is based for work purposes. And that's really the issue you need to consider. So they may have been, for example, working outside of the Newcastle City Council area, in Maitland or Port Stephens, for example, but it's where they're based for work purposes. So in that situation, they're not based in Newcastle, so they would have missed it anyway. But it's a local event. So therefore, it's not a local public holiday for work purposes. So what's your plan? We'll get to know what a public holidays may and how they may affect your business normal working days. Ensure you have a leave calendar or a staff log available to staff. Because when they say, what's a reasonable request to work on a public holiday, we're taking into account how much notice the employee's been given of the obligation to work on that day. Don't just tell them the day before. Is it that they're going to get a penalty payment for work performed on that day? The employee's personal circumstances as well. So have a look at the National Employment Standards and look at all those issues around a reasonable request to work. Train and educate your management team on around the issues around public holidays as well. What are the II implications of staff working on a public holiday? What happens if it's the day they work but they're not working? Are they entitled to normal ordinary hours for work on that day even though they're not at work? So look at the modern word for loading or the penalty, or that they get ordinary time for the hours they would have worked on that day. Implementing a standard practice that remind employees of the business expectations around public holidays. So we're an organisation that we're operating 365 days a year. So then you want them to work every public holiday. Or might be that that's the rostering, but give them notice. Take time understanding what additional staffing needs may be required. Maybe that you're okay for them to be off. You may need to bring casual employees to supplement the staffing for that day itself. Okay, moving on to fit with records, wages and pay slips. So what are the issues, and just some basic information around what employers are required to make and keep records in a form that is readily accessible to an appropriately authorised person, legible form and in English, be kept for 7 years, not be altered unless correcting an error, and not be false or misleading, and must be made available to current and former employees upon request. So employees now have a legal right under the Fair Work Act and the regulations to actually access their employment records. Now, some basic records that you need to keep is your hours of work. Now, you've got your requirements under the regulations, but you've also got sitting alongside your best practice stuff. and that is, okay, it says record of hours worked by an employee if they're casual or irregular. Well, you really should be keeping, best practice would dictate you would need to keep good and accurate records, and I would suggest you would do that for lots of different reasons, but mainly in regards to your full-time and part-time employees as well, or the very least, a record of overtime hours worked or when the employee started and finished the overtime. Any agreement to average hours, the pay record, the rate of pay paid to the employee. This is what the employer needs to keep. The gross and net amounts, any deductions from the gross amount. The details of any incentive-based payment, bonus, loading, penalty rate, or other monetary allowance, or separately identifiable entitlement pay. So if there's something in the award and loading, allowance, or penalty that they're entitled to, you need to keep a record of that. That's what they are entitled to. So you need to keep those details. The leave records, the leave taken, balance remaining, any agreement to cash out annual leave. So check your award, check the NES. Termination records. You need to keep records of how the employment relationship ended. Was the termination by consent, by notice, summarily, or did the employee resign? The name of the person who initiated the termination of employment. Super contribution records, the amount of contributions made and the dates and the period to which the contributions were made, and the name of the fund. When we're looking at pay slips, very important to know, are you comfortable and confident in the knowledge that you can say that the pay slips are being issued and the employee is actually getting their pay slip within 1 working day of payday? So are you comfortable? Do you know they are getting their pay slip? The obligations on the employer to issue the pay slip within 24 hours of being paid. And the content to include the employer's legal entity, so the employer's name, the legal entity, not the trading as, the employee's name including the ABN, the date of payment including the pay period to which it relates to, if paid an hourly rate, the number of hours, the hourly rate of pay and the amount at that rate. If they're paid an annual rate, the rate to which the payment relates, super contributions, the amount and the fund, and the deductions. And they've got to be reasonable deductions. There's a whole issue around what's deemed to be a reasonable deduction, including the name and or fund number or account. All components of pay, and this is where a lot of employers let themselves down because they're not providing as much detail as what they should be or what they could do as well. Any loadings, allowances, bonus, incentive-based payments, penalty rates, any separately identifiable entitlement, as much information that you can put on the payslip is better. It helps reconstruct the employment relationship. Someone can look at the payslip and go, right, and compare it to the award, and they go, okay, look, I'm getting all that and more. The gross and net amount. If you can put the employee's status on there, are they full-time, part-time, or casual? The name of the award, their classification. Best practice would dictate you should put as much detail on your payslip as you can. So what's your plan for your records, wages, and payslip information? Get started. Checking your current records. Are they complete and up to date? Because records can be used as protection in dispute. Documentation and evidence are very important. Examine a sample of your payslips for accuracy on a regular basis. Check the bona fides. If you're emailing payslips, make sure that the employee is actually getting their payslip if you are emailing them. Now, I know, and I get it all the time, the response straight away is, oh, they tell me if they didn't. Well, sometimes employees don't always know that you're emailing them, or they're even checking their email, or it's even an active email account. So just check the bona fides of those details. Timesheets should have starting and ceasing times, including breaks, and that's the starting and ceasing times of breaks as well, and should be true and correct as well. So, and if they're submitting timesheets, well, maybe you get them to a situation where they get the sign off and saying, look, this is a true and accurate reflection of what I'm working, and I'm submitting it to you in good faith. Fairwork.gov.au, they've got templates that help manage your record keeping obligations. So if you don't have anything that you can use, go on there and have a look at their templates page. Because identifying and reviewing your work practices, identifying payroll mistakes early can actually save a lot of time and energy and money. Now, if you're showing leave accruals, and you don't have to, there's nothing in the regulations saying you've got to put your annual leave, your personal leave on accruals on your payslip. If you want to, that's fine. Nothing wrong with that. But if you are, my suggestion is you make sure it's correct. Because if you don't, that's not the record, because you've got to keep the record. The payslip's just showing something you've got to explain. Taking the time to adopt some best practice steps and tips helps avoid fines for doing the wrong thing as well. So just some food